If you own a firearm in America, the legal ground just shifted under your feet this week. A massive wave of judicial rulings has just hit the federal system, and 10 existing gun laws, some that have been on the books for nearly a century, have just been modified, suspended, or completely torn apart. What I'm about to show you represents the single largest transformation of Second Amendment rights in modern American history. And understanding these changes is the difference between staying legal and facing life-altering felony charges that you never saw coming. Before we dive into the specific laws, you need to understand the constitutional framework that just changed everything. For decades, courts applied what legal scholars call intermediate scrutiny to gun laws. Governments could restrict your rights as long as they claimed some reasonable safety interest. That standard just collapsed. The Supreme Court's new history and tradition test requires the government to prove that any modern gun restriction has a clear historical parallel from the founding era of America. If a similar law didn't exist in 1791, it cannot exist today. This shift in legal analysis is why we're seeing a cascade of laws falling like dominoes across the federal system. The first major change targets what legal scholars call the vampire rule. In states like Maryland, New York, and Hawaii, the government tried to flip the Second Amendment on its head. They passed laws stating that carrying a firearm on any private property open to the public, like a grocery store, a gas station, or a restaurant, was a felony unless the owner specifically posted a sign saying guns were allowed. Essentially, your right to self-defense was dead unless invited in, just like a vampire needing permission to enter a home. But a federal appeals court just drove a stake through this rule. The court ruled that the Second Amendment doesn't require permission to exist in public spaces. The default has been flipped back. You are now legally allowed to carry in businesses open to the public unless there is a clear no weapon sign posted. This changes the daily life of every permit holder in the Mid-Atlantic region. No more wondering if you're committing a felony just by stopping for milk on your way home. The practical application is immediate. Property owners can still prohibit firearms on their premises, but they must do so explicitly through proper signage. The burden has shifted from you having to find permission to them having to post prohibition. Even in locations where firearms are legitimately prohibited inside buildings, the ruling eliminates parking lot restrictions completely. Vehicles in parking lots are now protected zones. You can legally store firearms in your locked vehicle in any parking lot, and property owners cannot prohibit this or search vehicles without a warrant. An estimated 2,400 people facing criminal charges for having guns in parking lots at work, schools, or government buildings are having those charges dropped immediately. The second transformation involves a law from 1927 that has stood unchanged for nearly a century. For all that time, Title 18 United States Code. Section 1715 made it a federal crime to mail a handgun through the United States Postal Service. It didn't matter if you were a law-abiding citizen moving to a new state or sending a family heirloom to a relative. Using the USPS for a handgun was a ticket to federal prison. The Department of Justice just issued a stunning memorandum admitting that this century-old ban is unconstitutional. Under the new history and tradition test, there is no historical equivalent from the founding era that justifies banning the mailing of common self-defense tools. This means the USPS is being forced to overhaul its entire shipping manual. For the first time in your lifetime, the federal government is backing down on a major non-mailable restriction. The implications extend beyond simple convenience. This ruling establishes that the government cannot create arbitrary barriers to exercising constitutional rights just because a particular method of exercising that right didn't exist in 1791. The internet didn't exist in 1791, but we don't accept government censorship of online speech. The Postal Service may be a modern convenience, but restricting its use for lawful purposes cannot survive constitutional scrutiny when that restriction serves no historical purpose. This principle is now being applied across dozens of other regulations that attempted to limit how you could acquire, transfer, or transport firearms. The third major shift involves the federal felon in possession law, which has operated as a blanket hammer for decades. If you had a felony conviction, even for something as minor as trying to pass a bad check 20 years ago, you lost your gun rights for life. The courts are now pulling that hammer back. In a series of landmark decisions, including Range versus Attorney General, judges have ruled that the government cannot permanently disarm people who have committed non-violent, non-dangerous offenses. If your past mistake didn't involve violence or a threat to public safety, the lifetime ban is officially on life support. The modification establishes clear restoration pathways. Mental health prohibitions received the most significant changes. The previous standard prohibited anyone who had been committed to a mental institution or adjudicated as mentally defective. That language was incredibly broad and caught people in situations that posed zero public safety risk. The new standard requires involuntary commitment based on a judicial determination of danger to self or others. Voluntary mental health treatment no longer triggers firearm prohibitions automatically. Someone who checked themselves into a facility for depression treatment keeps their gun rights. Someone who had a temporary mental health crisis 20 years ago and hasn't had issues since is no longer permanently prohibited. But the modification adds a critical requirement that provides ongoing public safety protection. Mental health prohibitions now expire after 5 years unless renewed through a new judicial proceeding with evidence of continued danger. The burden is on the government to prove ongoing risk, not on the individual to prove they've recovered. More than 180,000 people currently prohibited based on decades-old mental health records now have clear pathways to restoration. Thousands of Americans are currently in the process of having their rights restored because the court ruled that once a criminal, always a threat is not a valid legal standard under the Second Amendment. Drug-related prohibitions also received substantial modification. The previous law prohibited unlawful users of controlled substances from possessing firearms. Federal courts interpreted this to include anyone who used marijuana, even in states where it's completely legal. That interpretation just got struck down. The new standard prohibits only those convicted of felony drug offenses or currently under court-ordered drug treatment programs. Legal marijuana use in states where it's permitted cannot serve as a basis for federal firearm prohibition. Medical marijuana card holders are explicitly protected. An estimated 12 million Americans who use legal marijuana just regained Second Amendment rights. However, the modification doesn't change the Form 4473 question about drug use. You still have to answer truthfully, but a truthful answer about legal marijuana use can no longer be used to deny your purchase. The fourth transformation targets the National Firearms Act tax that has existed since 1934. If you've ever wanted a suppressor or a short-barreled rifle, you know the NFA tax. Since 1934, the government has charged a $200 tax for these items, an infringement tax designed to make them too expensive for the average person. But as of January 2026, legislation has officially taken effect, reducing that tax to exactly $0. While the registration process still exists for now, the financial barrier has been erased. The court's logic is straightforward and powerful. A tax on a constitutional right is no different than a poll tax for voting. If you paid a $200 tax stamp recently, you need to listen closely. Legal challenges are now being filed to demand refunds for everyone who was forced to pay this unconstitutional fee over the last several years. The removal of the NFA tax represents more than just cost savings. It eliminates what was effectively a class-based restriction on constitutional rights. When the NFA was passed in 1934, $200 represented several months of wages for the average worker. Even adjusted for inflation, the tax served as a deliberate barrier to prevent ordinary citizens from accessing these tools while remaining accessible to the wealthy. The elimination of this financial burden means that hearing protection through suppressors and practical defensive tools like short-barreled rifles are now accessible to all citizens regardless of economic status. The fifth major change involves the government's attempt to label entire categories of public space as sensitive places where firearms are prohibited. The government loves to label places as sensitive to keep you disarmed. They tried to include parks, museums, public transportation, and even outdoor gatherings, but the courts just handed down a massive rejection of these broad prohibitions. In a stinging rebuke to state legislatures, a federal judge ruled that the government cannot simply label the entire world a sensitive place to circumvent the Second Amendment. The modification establishes a strict definition of what qualifies as a sensitive place, and the requirements are demanding. Locations must have heightened security measures, including controlled access points and active security personnel. There must be a demonstrated history of security incidents at similar locations. The restriction must be narrowly tailored to the specific security concern. Here's what this means practically. Courthouses with metal detectors and armed security remain prohibited. Elementary schools with secured entrances and resource officers stay on the list. But public parks with no security infrastructure cannot be designated sensitive places. Libraries without controlled access lose prohibition authority. Shopping malls that don't employ security cannot ban lawful carry. Government buildings received specific scrutiny under this new framework. The modification requires actual security screening to justify firearm prohibitions. A city hall with open public access during business hours cannot prohibit concealed carry. A Department of Motor Vehicles office where anyone walks in freely cannot ban firearms. If there's no metal detector and no security screening, there's no legal basis for prohibition. Prohibitions on carrying in state parks and on public transit have been struck down in multiple districts. The court's message was clear. If the public is allowed there, your rights are allowed there. The prohibition signs posted at thousands of locations across the country just lost legal authority. The sixth transformation addresses ammunition access. which several states have attempted to restrict through background checks and registration requirements. You can have the best firearm in the world, but if the government can cut off your access to ammunition, the right is functionally dead. If you live in a state like California or New York, you've been living under a bullet tax for years. In California, every single time you wanted to buy a box of 22 long rifle or 9mm, you had to pass a background check, pay a fee, and wait for a computer system that frequently crashed. It was designed to make shooting as expensive and annoying as possible. But in a massive win for the Second Amendment, the Ninth Circuit Court of Appeals, long considered the most anti-gun court in the country, just struck this down in the landmark case Road versus Bonta. The court's logic was simple and irrefutable. A firearm is just a paperweight without ammunition. Therefore, any onerous background check on bullets is an unconstitutional burden on the right to keep and bear arms, because there is no historical tradition from 1791 of the government tracking every single bullet sold. The court ruled that these laws cannot stand. As of right now, background checks for ammunition in the Ninth Circuit are being dismantled. However, the ruling doesn't eliminate ammunition background checks entirely. It adds critical protections and limitations on how they operate. Ammunition background checks must use the same NIC system as firearm purchases with identical privacy protections. States cannot create separate ammunition purchaser databases or licensing systems. California's ammunition purchase records that tracked every round purchased by every individual just got ordered destroyed. The modification caps ammunition background check fees at $1 per transaction regardless of quantity purchased. California was charging $1 per box, meaning someone buying 10 boxes of ammunition paid $10 in background check fees. That's reduced to a single dollar per transaction no matter how much ammunition is purchased. This doesn't just affect California, it sends a warning shot to every other state trying to implement ammo registries. The era of being tracked for buying a box of range ammo is officially ending. The seventh major change involves age restrictions on handgun purchases. For decades, the federal government has treated 18, 19, and 20-year-olds like second-class citizens. You were old enough to vote, old enough to sign a mortgage, and old enough to be sent to war with an M4, but the ATF said you weren't mature enough to buy a Glock from a licensed dealer. That just changed. The Fifth Circuit Court of Appeals issued a decision in Reese versus ATF that has effectively ended the federal ban on federal firearms licensees selling handguns to young adults. The court found that at the time the Second Amendment was written, 18-year-olds were not just allowed to own guns, they were required to in the militia. This ruling is spreading like wildfire across the federal court system. We are seeing young adults across the country filing lawsuits to demand their right to purchase handguns and obtain carry permits. If you are 19 years old and living in a state that was blocking your permit, the legal wall just crumbled. The courts have affirmed that the people means all adults, not just those over 21. The implications extend beyond simple purchase rights. States that maintain 21-year minimum ages for carry permits are now facing immediate legal challenges. Early court decisions suggest these age restrictions cannot survive the new constitutional standard. Young adults who can vote, serve on juries, enter contracts, and serve in the military cannot be denied fundamental constitutional rights based solely on age. The eighth transformation targets what the media calls ghost guns and the ATF's attempt to regulate home-built firearms. You've heard the media scream about ghost guns for years. The ATF tried to bypass Congress by redefining what a firearm is, claiming that a block of plastic or an 80% receiver was a gun. They wanted to force every hobbyist and home builder to register their projects and go through background checks for pieces of metal. However, the Supreme Court and several lower courts have been hammering the ATF for overstepping their lane. While there is ongoing litigation in the Supreme Court, a new series of injunctions has protected the right of law-abiding citizens to manufacture firearms for personal use without a serial number. The latest judicial rulings make it clear. The ATF does not have the power to write laws. They only have the power to enforce the ones Congress actually passed. Because Congress never passed a law requiring serial numbers on home-built guns, the courts are siding with the builders. If you enjoy the hobby of building your own tools, the latest modifications to these ATF rules mean you can breathe easier. The frames and receivers rule is being shredded by judges who are tired of executive agencies acting like kings. The principle established here extends far beyond ghost guns. Federal agencies cannot expand their regulatory authority beyond what Congress explicitly authorized. For decades, agencies like the ATF have operated by issuing interpretive rules that effectively created new laws without congressional approval. This judicial pushback represents a fundamental shift in administrative law. Agencies must now demonstrate clear congressional authorization for any regulation that restricts constitutional rights. If the statute is ambiguous, that ambiguity cannot be resolved in favor of restricting rights. The ninth major change involves Fourth Amendment protections against warrantless searches, which have particular application to firearms owners. For years, the ATF and certain state agencies operated under the assumption that if you held a federal firearms license or were a registered collector, you had essentially signed away your Fourth Amendment rights. They used compliance checks as a loophole to enter private property, inspect home-based businesses, and demand access to safes without ever seeing a judge. But recent Supreme Court precedent has sent shockwaves through federal law enforcement. The court ruled that administrative necessity is not a substitute for the Fourth Amendment. The new ruling is explicit. Unless there is a clear immediate emergency or a warrant signed by a judge based on probable cause of a crime, federal agents cannot enter your private property for a surprise inspection. This effectively ends the era of knock-and-talk harassment. If an agent shows up at your door demanding to check your books or verify your inventory without a warrant, you now have the constitutional standing to say, "Show me the warrant or leave my property." And here's the critical enforcement mechanism. Under new officer accountability standards, any agent who ignores this ruling and forces their way in can now be held personally liable for damages. We aren't talking about the government paying a fine. We are talking about the agent's own bank account being at risk. This protection extends to regular firearms owners as well. Police cannot demand to inspect your firearms, check serial numbers, or verify storage compliance without a warrant based on probable cause of a specific crime. The practice of officers automatically disarming everyone during traffic stops is also under legal challenge. The modification establishes that taking someone's firearm during a routine stop requires articulated safety concerns based on observed behavior, not blanket policy. Officers who violate these standards face the same personal liability for wrongful disarmament. The 10th and perhaps most critical transformation involves interstate travel with firearms, which has terrified gun owners for generations. Historically, if you lived in a free state like Virginia or Pennsylvania, and you were driving to a shooting competition in Vermont or Maine, you had to pass through the gauntlet, states like New Jersey, New York, or Maryland. Under old laws, even if your gun was locked in a box, unloaded, in the trunk, a single traffic stop for a broken taillight could land you in a jail cell with a 10-year mandatory minimum sentence. Police in these states routinely ignored the Federal Safe Passage Act, claiming it was only an affirmative defense you could use after you spent $50,000 on a lawyer. That fear is officially finished. Following a massive federal injunction and recent Department of Justice determinations regarding the right to travel, the legal standard for interstate transport has been completely overhauled. The courts have ruled that the Second Amendment contains an inherent right of transit. Under the new Transport Freedom Mandate, 3 critical protections now exist. First, strict immunity. If your firearm is legal in your home state and legal at your destination, you are granted absolute immunity while in continuous transit through restrictive states. Second, no arrest power. Police are now prohibited from arresting or even detaining you for simple possession during transit if you declare you are traveling under federal protection. Third, the 10-year felony is dead. The court has ruled that states cannot turn a constitutional right into a felony just because you crossed an invisible line on a map. This ruling is so powerful that it is being applied retroactively. Thousands of people who were previously convicted of unlawful possession while traveling are now filing for vacatur of their sentences. What used to be a 10-year prison sentence is now recognized as your constitutional right to move freely across the United States. The modification also establishes permit reciprocity requirements. Every state must recognize carry permits from every other state, but only for permit holders visiting temporarily. The requirement applies to anyone in a state for fewer than 90 consecutive days. If you're visiting for work, vacation, family matters, or any other reason under 90 days, your home state permit works everywhere. However, states maintain authority to set their own requirements for residents. If you move to a new state and establish residency, you must obtain that state's permit within 90 days. Your old permit stops working after establishing new residency. The modification also eliminates duty to inform requirements during police encounters. 12 states previously required permit holders to immediately notify police they were armed during any official contact. Those requirements are now unconstitutional. You can volunteer the information, but officers cannot demand it unless they have reasonable suspicion of criminal activity. These 10 transformations represent the single largest expansion of Second Amendment rights in American history. From the $0 NFA tax to the restoration of rights for young adults and the end of the vampire property rules, the judicial ground has indeed shifted. But here is the most important part. These laws only protect you if you know they exist. If you are stopped by an officer who hasn't read the latest 2026 memos, or if you are facing a red flag order from an ex-spouse, you must be able to cite these rulings. You are no longer a suspect for exercising a right. You are a citizen protected by the highest tier of constitutional scrutiny. Understanding these changes requires recognizing the broader legal framework that enabled them. The shift from intermediate scrutiny to the history and tradition test represents a fundamental change in how courts analyze gun laws. Governments can no longer simply assert a safety interest and restrict your rights. They must prove that similar restrictions existed and were accepted at the founding of our nation. This burden shift from citizens to government is producing the cascade of falling restrictions we're witnessing. But these protections come with responsibilities. Anyone who completed private transfers in the 60 days before certain rulings took effect may have a 90-day grace period to register those transfers retroactively without facing any penalties. That window closes fast, and missing it means potential felony charges. If you own firearms that were classified as assault weapons yesterday, possession is immediately legal, but some states are fighting implementation. Gun owners should document their compliance with modified laws while understanding that state-level prosecutions will likely fail under federal court review. The modification also creates new responsibilities regarding storage, particularly for households with prohibited persons. If you live with someone legally prohibited from possessing firearms, you must store all firearms in a manner that prevents their access. This means locked safes or other security measures that don't rely on trust or promises. Failure to secure firearms when living with prohibited persons creates strict liability for any resulting access. The application gets complicated quickly. Your adult son moves back home temporarily after a conviction that included a prohibition. Your firearms must now be secured in ways that prevent his access. A roommate develops mental health issues and gets involuntarily committed. Your storage requirements just changed immediately. Additionally, firearms left unattended in vehicles must be secured in locked containers or hidden from plain view. If you park your car and leave a gun inside, it cannot be visible through windows and must be in a locked glove box, console, or trunk. Failure to secure firearms in unattended vehicles creates civil liability if they're stolen and used in crimes. More than 380,000 firearms are stolen from vehicles annually, and most thefts occur because guns are left visible in unlocked vehicles. Someone breaks into your car, steals a visible firearm, and uses it in a crime. You could face civil lawsuits from victims arguing you failed to secure the weapon properly. These changes only protect you if you understand them completely and use them correctly. The difference between a law-abiding citizen and a felon is often nothing more than knowledge of current legal standards. Officers, prosecutors, and even judges may not be fully updated on these recent modifications. You need to be prepared to respectfully assert your rights while maintaining courtesy and compliance with legitimate authority. If confronted during a stop, the protected response is clear. I'm not required to identify myself unless you have reasonable suspicion of criminal activity beyond legal firearm possession. What specific crime do you suspect I've committed? This phrase asserts rights while maintaining appropriate respect for law enforcement. The broader implications of these changes extend beyond individual rights. They represent a judicial recognition that the Second Amendment receives the same high level of constitutional protection as freedom of speech, freedom of religion, and other fundamental rights. For too long, gun rights were treated as second-class rights that could be restricted whenever the government claimed a safety interest. That era is ending. The judiciary is now requiring the same rigorous justification for gun restrictions that would be required for restricting any other fundamental constitutional right. This shift affects every aspect of gun ownership, from purchase to possession to carry to transport. Background check systems must operate efficiently without creating undue delays. Waiting periods cannot exceed what is historically justified. Prohibited person categories must be narrowly tailored to genuine safety concerns. Sensitive place restrictions must be limited to locations with actual security measures. Ammunition access cannot be restricted beyond what applies to firearms themselves. Age restrictions must align with other rights and responsibilities of adulthood. Manufacturing regulations cannot exceed clear congressional authorization. Search and seizure protections apply fully to gun owners. Interstate travel cannot be criminalized. What remains critical is that gun owners understand both their expanded rights and their ongoing responsibilities. The legal landscape has shifted dramatically in favor of Second Amendment protections, but this doesn't eliminate all regulations or create unlimited rights. Prohibited persons remain prohibited, though the categories are now more narrowly defined. Sensitive places remain restricted, though the list is much shorter. Background checks continue, though they must operate more efficiently. Storage requirements exist, though they're now clearly defined. These modifications represent a rebalancing of constitutional rights and legitimate government interests, not the elimination of all regulation. Moving forward, gun owners should document their compliance with current legal standards, stay informed about ongoing legal challenges, and be prepared to respectfully assert their rights when necessary. The changes described here represent the current state of the law, but litigation continues across multiple jurisdictions. Additional modifications and clarifications will emerge as courts address specific applications of these new standards. The fundamental shift from intermediate scrutiny to the history and tradition test, however, represents a permanent change in constitutional analysis that will continue producing expanded protections. These 10 major transformations only protect you if you know they exist and understand how to apply them in real-world situations.